Right.
Yep, oh, that's right. It's 6 o'clock.
That's right. Okay.
Alright. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
This is another joint session on signage. I just as a matter of housekeeping, wrote a couple procedural notes. Alex is going to recap for us where we left, what we continued at the last session, and then we will start where we left off, which is I guess section 17, and then we will look at some of Ron's answers on legal questions we asked, and then we'll develop our plan to meet again before we have a final draft.
Procedural on my side. My son has his Christmas concert at 7 o'clock, so I'm leaving at 6:45.
You enjoy it. Excellent.
Well, we're 100% gonna
Good for you.
make sure meet that then.
Yeah, thank you. Thanks, Mr. Chairman, members of the board and commissioners. So at your last meeting, you spent some time going over P&M's review of section 7 sign illumination standards. There was a discussion on waivers and waiver language, which is will be forthcoming. You don't have it tonight. There's a pending discussion on potentially some examples of signs currently existing versus these standards. And then there was a discussion on section 17, A, B, and C, and tonight we should begin on section 17D. Yeah. So that would be basically, if you want to jump into it, Jacob, you could just start. It'd be, you should have it right in your packet. It should open up right to that first page.
And remind me, in this section on 17, we did say we thought we should do a better job of
What section?
17. Of defining the difference between
Next.
abandoned, unsafe, and lawful.
Yeah, that's correct. It was more specifically, there needs to be more detail to add criteria of what exactly constitutes an unsafe sign or nuisance, and then there's an action item for Ron and Scott to discuss section 17(1)B to address the notice dodging. Does that answer your question?
Yeah.
Okay.
I just want to bring us up to speed if we're going to start with this section.
Did we come to a resolution on online signs as being no different than digital signs or different? I can't remember.
There was a lengthy discussion between the board and your solicitor on that. And as I recall, there was no consensus.
I thought we wanted to pursue a separate ordinance that dealt with false advertising. I think that.
Well, you have false advertising included here for signs, right? Section 17, unlawfully erected in violation of any of the provisions of the ordinance. And it seems like what we get online and what we get on a digital sign are kind of merging, since both of them are controlled by some central computer somewhere or server. And in fact, if it wasn't for the fact that it must be at least 8 seconds of something appearing on a sign before it changes, you could probably put TV on a sign too. So I don't know what the difference.
I don't think
I
anyone's going to define a screen as a sign. They're
Well,
different. A
okay,
sign
think of it.
is a physical object that is.
But Michael, it is a screen today. That's what it is.
I understand, but a sign can be a screen, but not all screens are signs. A screen in your
Right.
house is not a sign. Similarly, you're talking about advertisements and banners online. That's not what a sign is.
Right.
I mean, we define what a sign is here, right? I mean, if you want to try to do that, but I think you're just gonna start
mean,
turning on
you're saying-
real tight, difficult.
That advertising is not something you see online.
It is.
No,
I think
advertising is not a sign. That's, you're talking about advertising
Correct.
and trying to govern advertising through a signage ordinance, and I just don't
I think
think
we
that's
can, that's why
appropriate.
I said I think we can achieve that goal separately, because it still is. You know, unlawful, if you're advertising unlawful use, I think we should be able to. You know, put the hammer down on that, but I don't think it belongs in the signage. Like, I think we should just take up a false advertising
Well,
ordinance.
I would agree. The only problem is if it's a false advertising and you say it's online false advertising, how do you say you can control it from the township since it's everywhere?
I don't think
Well,
that,
only if
I don't
it's-
think that answer,
You can't only, I mean, the thing you could potentially, I don't, you know, have to ask legal, but if you're advertising something that is happening in the township. Maybe, I don't even know if you can do that.
Ron, what do you?
Scott?
I think you were
Right,
talking, I think this conversation started about the temporary homes, like
short-term
vacation.
rentals.
It's
Yeah.
related to thirty.
Correct.
That's, I
Short-term
think that's where the
rentals,
conversation started.
Yeah, that's what it's.
So what you're
about.
saying, if somebody's advertising in a temporary or home rental that's not allowed in the township, you should be able to shut that advertising down?
Well,
That's
that-
a lot.
Robert is suggesting in this ordinance on signage, we could make that advertisement potentially illegal, not illegal, but citable because it's a sign. I disagree. I don't
Yeah, I
think that
don't
makes
think
any
that
sense.
wasn't the intent.
But I would also say having it online can be helpful for us because then it can point to an illegal activity and then would help us to enforce that.
No.
like,
Well,
don't know.
the other practical matter is unless we have an ordinance specifically for that, we have to cite it through our zoning ordinance, which just doesn't work for many reasons.
Is there a precedent on this, that somebody's done this
I don't
before?
think
This is.
I don't think you can get away from zoning on that. I mean, you could, I don't know, Ron, is there such a thing as illegal advertising that's?
Again, and we talked about it the other night, that, you know, there are situations in which arguments are made that you are engaging in de facto zoning, and as a result, that ordinance or statute that you're developing may be attacked, et cetera. I don't know if you want to mix the advertising and the signs together. I agree with Robert that they are signs, but I think I also agree with Michael that mixing them together may not work. You know, where it may be better to just do it, you know, separately. But it's a policy call. If you want to say a sign includes screen advertising, well, then that's what your ordinance says it includes. Whether it's attackable or not, who
When
knows?
it's a digital billboard, sure, but
It's a physical
it's
device.
distinct.
What you're talking about online is technically not physical until it manifests on
Right.
the screen, which could be anywhere.
Right.
So yes, if that manifestation of that online advertising is a physical structure that is in the township, supposedly not in your home, that can be enforced, but you can't
Yeah,
say.
I'm
you
not
can't have
there
it.
yet. I'm talking about those screens that change signs, et cetera, that you go around.
Well, that's in here. It's a
Okay,
digital
that's what
sign.
I'm saying.
Yeah, it's
Right.
already.
I'm not at the online place
Right.
yet because I just haven't thought that through. Maybe Scott may have some ideas or may have run across it in his practice, but I'm not there yet with that online stuff.
And understand, I'm not doing this to try to force something in here. I'm just looking for a way that we can somehow control these online ads because we don't seem to be able to control Airbnb through the process we have now, which is through citing them under the zoning laws, waiting 30 days to see if they file, seeing if we can reach them or not. I mean, it's very cumbersome.
And then you're gonna have to start looking at all the rental sites to
Well,
see who's renting.
Well, see, I think that these are a couple of distinct issues that we can. I think if we wanna talk about, tenant administration, all that jazz, we can do that, but I don't think that. I don't think it's gonna fit in this ordinance, but I think that some of the things that you talked about could fit in another.
Or maybe you can fit in an update to the short-term rental ordinance that has more enforcement things. Because that's really what you're talking about.
Correct, that's still in chapter 27, but I don't like we talked about on. One of our, with one of our several meetings this week. I don't think that everything can necessarily be outside of zoning, this kind of seems
Talked about
squarely
yesterday.
within, yeah.
Like yesterday.
Yeah, that seems squarely within zoning, but let's. can we agree to move on to the
Yeah,
other,
let's move on.
cause I think that we can discuss that in one of our upcoming
Okay.
meetings.
Yes, so back to 17D, Ron had given the township a comment, and I'll just read Ron's comment, and rather than have everyone flip through the pages to get to reading Ron's comment, because it's only one sentence. So Ron said, paragraph section 1D, the last sentence should have the following language added. All reasonable costs associated with the removal of sign, including witness costs, court costs, and attorney fees as may be applicable. And 17D is a provision which, under section 17, removal of unsafe, unlawful, or abandoned signs. I don't know if you want me to read that whole thing out.
No.
Okay,
That's not already says that.
but basically it's. What is
All
it?
reasonable costs, you wanna make sure that it includes attorneys, because they're generally not.
That was my suggestion.
Yeah, right, cause that's
Make sure
generally
that
not a
witness fees,
default, yeah.
Attorney's fees, court costs.
Yeah, that's understandable.
I can't tell you how many times, and I'm sure you have two people who fought about,
Oh,
does
yeah.
it cost or not, doesn't mean that, it doesn't
Well,
mean
can I
this.
just say, in this situation, the attorneys would never be contacted. We're talking about removing a dilapidated sign. And if it's a giant billboard and no one's in touch, you have to hire someone to remove it. It gets removed. They get sent the bill. That's what this is about.
What about filing the lien?
That's what it says there.
That's what that-
Okay, so, and then filing the lien would be the legal.
Yeah, that's the
cost
last-
of the lien. So yes, you're right on that point.
Okay, moving on to section 18.
So just for, you're taking notes of these and you're gonna make the amendments for the next draft, is that correct?
Correct.
Okay, good.
So moving on to section 18, permits applications. This is a pretty crucial section, so I think it's important for everyone to go through it. Again, I don't know if you want me to read every one. I can just kind of go over what it says here.
No, let's go over.
Okay, so basically, signs need a permit in the township, right? And in order to apply for a permit, section, 2 has a bunch of items and details that must be included in the permit. And the difference, what you're looking at in front of you includes permits for limited duration and street pole signs as well. And the difference between general signs and limited duration signs is that limited duration is 1-year permit and all the other ones are indefinite, basically, unless there's some changes. So that's all the way to H, and then there's a number of copies of signs that have to be provided and all details necessary to confirm that the sign is to be installed complies with the requirements set forth in this chapter. And then it says, depending on this sign type and location, this may include, and it goes through 3 different things like lot dimensions, frontage, elevations, proposed facades, current photographs showing existing signs and certifying the date on which the photographs are taken. And then next section says, if not the owner of the property, written permission from the owner. And then in the case of a street pole banner, permission of the person who owns the pole or entity that owns the pole. And then there's a fee, which is determined by the Board of Supervisors in their fee schedule by resolution. And then it moves on to number 3. And this is a section I think we probably want to have some discussion on. So it says Smithfield Township shall have 30.
Hold on, can we go
Yeah.
let's just talk about
Yeah.
section 2, because this is, I think actually that's the more
Okay.
important. 2H, that's the meat. And I just want to give some info here, because we had a long, Dave and I and Alex had a long conversation actually on this section. Because the original ordinance had a few things that every single sign had to submit a elevation and things like this. Even though if you then go further up, for some of the signs that required a permit, there was no requirements related to elevation or anything. And I thought that's overreach and overkill. And why do you need to know if you are putting, I don't have a particular example beside, but if you're a business and you are allowed 4 square feet signage on the side of your wall, that's the only thing you're planning to put in. You shouldn't have to put in a full plot of building elevations, existing parapet wall, like it's.
I agree.
Right, so the language was changed to say, you must submit all the information to prove that it meets everything in this ordinance. But then it does say it could be these things.
May include, yeah.
Does that, I'm looking at you, Scott, and you're,
Well,
I can imagine you hate the word may in a document like this.
Shouldn't it be shall be one of these rather than.
But it's not, it might not be, literally, there are.
Right, not, if it's on the side of a building, you're not gonna worry about it, the building's already there.
You don't care about-
You
I
don't
mean,
care.
And honestly, if you go through the entire ordinance, there's no requirements for elevation, there's no requirements, so why are we forcing people
It's
to
really only,
spend
it's really those,
significant money to do something if
yeah,
it
there's
doesn't
no,
inform anything?
well, no, there's no point for that. The only time you're worried about that is if you're gonna otherwise build something that you're gonna put the sign on.
Right.
At which point you're gonna be in a building permit anyway.
Right. And then, in which case, there's regulations within this ordinance that say you have to meet
Yeah.
certain, so if you have to meet a certain elevation in this ordinance, then you're gonna have to show the elevation. I just wanna make sure that everyone, because that we amended that a little bit.
Yeah, I don't need to, and I don't think you need to make it overly complicated, to be honest with you. I agree with you. I think that it was, it's gonna just engender a significant expense that the people probably don't want to deal with.
I have one,
And for no real gain for us.
Right,
For
and
no
actually, extra paperwork and confusion, why?
Right, for no
what am I
benefit
supposed
for
to do?
Yeah, I guess I'm just confused why.
I have one question
Why the
It's
may?
triggered.
Yeah,
Yeah,
what is it, James? So,
on section 18:1. What kind of repair would require a permit? Wrecked, alter,
Those
repair.
provisions are, I think that's a non-conforming later on in one of the next sections. It gives like a percentage, like for example, like on page 60. There, I think that will be answered as we continue in this.
50% of sign area is damaged.
Yeah. So
In there.
if it's okay with you, maybe I'll make note of your question, then we'll come back to it when we get to that.
It just reference
Or, yeah, we could do that.
that to the 4, right? 19:4.
So you would like to, in
Well,
that,
because it should, somebody may see that,
so it,
like,
mhm.
fixing a light bulb or something.
Mhm. So the words alter and repair should then reference that section that I had.
I think it should.
It's not a bad idea. I think it's, what does everyone else think?
Won't hurt.
Okay.
Just to be clear, you said it should reference section 18.4,
19,
19. Thank you.
paragraph 4.
At least just reference section 19 at minimum, I would say.
Yep.
And then any other applicable sections, I'll have to go through all ordinance and just make sure there's no other places.
It's not that section, that's just about non-conforming signs.
that's a non-conforming.
It is written somewhere, you have to find
Okay,
the reference.
that's what I had. a
It's
feeling.
it says the same thing, but it's somewhere else.
Okay, so at the applicable section will be referenced. Okay,
Okay.
okay. So the next section was number 3. So once an entity submits a permit to the township has 30 days to review it.
Mhm.
And then if the township for whatever reason doesn't review it within 30 days and get back to that person, it's deemed approved, which could have permanent ramifications. So I don't know if you want to increase that length of time for the review, especially if they're pretty complicated, to like 60 days, so that you don't get a deemed approved.
I really think
It's
30
up to you
days,
guys.
when it's not going before a governing body for approval.
Okay.
I really wanna see it within 30 days.
Yeah, that's not unreasonable.
Okay.
Yeah.
What, do we have this already for a building permit? What is the time frame? Thought it was 30 days already.
The building permit is 15, I think.
15, yeah, so I mean, we might be even hard pressed to say it has to be 30, because. Building.
We can leave it,
it.
doesn't have to be the same.
I think 30 makes maybe a little bit more sense, only because some of them will be more complex that will have to go elsewhere, and when they're getting these permits. I mean, you obviously need, if you're doing something electrical, you need to get other permits as well before this becomes in effect.
Also, if it's missing something, it
Yeah.
can be considered not accepted, right? Because
Yeah.
it didn't have all the information.
Be not administratively complete.
Yeah.
Yeah, the township, that's the next section is, if there's something wrong with it, the township has to respond. And then, inform the applicant of the reasons for denying it, so if it's
Right.
administratively.
Certified mail.
Yeah.
Yeah.
And then
Wait, by certified now?
Well, it says,
Number six says-
Smithfield Township, number 6 shall inform the applicant of the reasons for denying the application for sign permit by certified mail.
I don't know if we need that, but
Should
do
we
you
change
think we need
that?
that just so we have the date on
You
it?
don't need that. They came to you, you don't need that.
That's
Yeah.
$8.
Okay, remove it.
What should be, by just inform the applicant
Yeah.
by first
No,
class?
don't say anything about mail,
No.
reference mail, because they might have walked in and a phone call usually is how building permits are being informed.
For sure. I mean, you can say.
No,
written notice.
denial should be written.
Yeah, I would say,
Okay.
say written notice.
Denial needs to be written.
But don't reference the mailing of it.
By written notice.
Yes.
Yeah.
So that could be electronically.
Okay, so 18.7, this is appeals, so upon denial, the applicant has 30 days to revise and revisions and appeals, to revise and resubmit the application for review. In the alternative, the applicant may also appeal. The applicant may also appeal the decision of Smithfield Township to the governing body within the 30-day time period, and then Smithfield Township at its next regularly scheduled meeting shall review the township's denial of the application. Thus, it's not a hearing necessarily, but
Can we just be clear and say like the Board of Supervisors?
Yeah.
In place of Smithfield Township?
yeah,
Ideally, we're not gonna get signs going before the planning commission either. I want this to be.
We may have to make that correction throughout the
Yeah,
ordinance. That's been used quite a bit.
yeah.
Doc, I would probably also put in that first sentence where it says upon denial of the application for sign permit. The applicant has 30 days to revise and resubmit. I'd probably put so it's clear, has 30 days from the date of the denial to revise and submit. So we're not fooling around with what 30 days are we talking about, whatever, so. Again, the applicant has 30 days from the date of the denial to revise and et cetera.
I agree.
I think we just-
And then 8. This is, let's see here, it says, this is explaining the duration of the permits. So it says, with the exception of permits from limited duration, which I've mentioned are 1 year, and then street pole banners. Sign permits shall not expire provided that such signs are not abandoned or destroyed. And then the last sentence states that limited duration signs and street pole banner permits are issued for 1 year and may be renewed by approval by the board of supervisors. So
We're not gonna have any of those anyway.
just so everyone's clear on how that.
When the duration's not there. Sorry.
Is everyone comfortable with that provision? Okay, and then the final 1.9 is illuminated signs.
So everyone remembers, limited duration signs are not for a year,
Mhm.
they're for a short,
Yeah,
but usually it's like, I
An
would
event.
have this. For an event, so it doesn't mean that when you get a limited duration sign permit, you can have it every. July, you do have to apply every year to do.
What if you're gonna do it twice in 1 year?
You, there, we have to go back to limited, I'm sorry, it's not in front of me, the limited duration signs, as we went over last time, I think allow up to 2 times per year. For, I can't remember, 3 months total, something like that.
Okay.
That might not be exact, right, but
Yeah,
it's something like that.
Thank you.
And the last one has to do with sign illumination again. I know we talked about that at length the last meeting, but it
Yeah.
says all illuminated signs shall require. Certification in order to demonstrate continued compliance with the brightness requirements set forth in section 7 sign illumination standards. This certification must be reviewed every 3 years. Okay, and then Smithfield Township also has the right to assess the brightness of any sign at any time to ensure compliance with the illumination requirements.
Did we, I think we talked about this, is there an actual certification that exists? Cause I don't wanna get to what we had with the noise ordinance where we're talking about certification and then in the end, it's like, oh, it doesn't even exist.
hold on, but talking about having a certification. That someone's sign meets.
It's around like when you're, it's like manufacturer certification.
Oh,
of the
okay, I was
lights.
gonna say, cause this,
No, it's not about our certification, it's about the, it's.
cause loosely it sounds like, you know, how you have to have your septic inspected every couple of years. I was like, I don't wanna, we don't need someone.
No,
to
this
go
was,
check
this
signs
came
every
from the
couple-
model ordinance and it was related to like. Limiting people from saying, yeah, it's, you know, it says it's only whatever candles, but it was
Right.
made in China and it's 10 times brighter. It has to have some sort of, But I think we were supposed to look it up if such a certification actually exists. I mean, you might want to be specific there, but
Who's gonna, monitor whether or not it's too bright? Or not bright enough, or it meets the ordinance,
You would be a code enforcement officer,
the code enforcement officer.
yes.
right? Yeah, 'cause
Or,
this is
or,
a neighborhood
or when
check.
they submit.
Or complaints.
Oh, well, however it gets there, yeah, that's the.
Or, I'm sorry, complaints, what?
Well, right now, that's how largely enforcement is done. It's
Yeah.
like, if someone complains about something that's too bright, the code enforcement would go out there and test.
Mhm.
Have you seen the complaint form? I'm sure you guys have.
It's very basic.
Yep.
You gotta put your name on it.
Mhm.
Yeah, it is redacted, but it's required. You can explain the legal side of that. It's there.
When you file a complaint with the township,
Right,
whoever files the complaint with the township is protected under the state constitutional right to privacy. So we have that information. So if you submit a complaint, for example, and that ends up going to court, we need to be able to yank you into court and say, this is why. And then you will be able to testify as a witness for that.
Or not, if you choose not.
Or
to.
not, if you choose not to, but
Yeah.
we need to be able to contact you for those sorts of things. But under no circumstances, let's say you submitted a complaint against Bob, and Bob went, hey, I wanna know who did that. We can never say, oh, it was Doug.
It's not available in the right to know.
right. There's all kinds of feuds that go on in some of these small townships.
Yes,
One guy complains and who knows what happens to him. The person complained against shows up at his house at midnight one night. And, complains to him. This never happens. I mean, you can't envision that happening.
I can
I shouldn't be
imagine.
asking these guys.
No, I think we can all imagine a scenario where somebody learns that a complaint has been filed against them and goes, oh, it was this person, I know it for
Oh,
sure.
sure.
And that we cannot stop people's assumptions, but we will not be able to provide that information to
Unless it
anyone,
happens at court.
unless it goes to court and that person is willing to testify in court.
Let's see. What's ominous? I mean, I'm not saying I'm gonna go out right now and start issuing a whole sheaf of complaints. I'm just saying that it's a little ominous that we could be dragged, anyone, any township citizen or resident could be hauled into court and asked to testify.
I mean, you
But
need a
how
witness
else
for
could
a
you
good
prove-
case.
how else
Put
could you
yourself
prove
in
the
that
case?
place.
Oh, plenty.
How else could you prove the case if you don't have a witness to support your position?
Right. No, I understand why it's there.
Well, then that's moot then. Okay.
Because if the code enforcement officer's measurements and violation or not.
Yeah, exactly. Yeah, I mean, ideally it wouldn't be there, but, can we keep going?
Yeah, next section, just to be clear, there was so Ron did not have any comments on 18, so we don't have to go over any there, and Ron also doesn't have any comments on 19. Just so we're clear, because in your packet, there's Ron's review of certain comments, so there is one coming up, that's why I'm mentioning it. So 19 is non-conforming signs.
Yeah, that's non-conformant stuff,
Yeah, so. Just trying to see here, so basically, so the first one is signs legally in existence at the time of the adoption of this ordinance, which do not conform to the requirements of the ordinance shall be considered non-conforming signs. Right, all permanent signs and structures shall be brought into conformance with the sign regulations when and if the following occurs, so there's a number of reasons where non-conforming signs must then adhere to the
They're
standards.
becoming new signs. effectively.
Exactly, yeah.
Therefore,
Yeah, in
they have to be
essence,
covered.
you're right.
We're just
This
being
is-
very explicit about it. The next, so I will say, I mean, section. Where is it? The last point in here is the one that could be contentious that I would love to hear Ron and maybe Scott's
one?
opinion on. So again, this is why we put things like banner signs under temporary, was because. By definition, a temporary sign is a specific period of time, And this basically says, any of these things that are temporary. After 90 days of this going into place. Would have to be removed if they're non-conforming. And that's the question, where do we have the right to do that? So for example, there are flag signs, flag banners,
We'll pull them out of the ground.
that after this covenant.
I don't know why we haven't, to be perfectly blunt.
Well, because it's not,
No.
I don't.
Why not? They were never permitted to begin with.
When some-
Under anything, under the existing one, they're never permitted. I don't know why we haven't. I don't know why they're still there, but I've gone through this before, so. Okay,
Well, my understanding is this says they would have to go. Under those 90 days, because they're not a permanent sign.
Why would you think that you could not do that when you looked at?
Well, because on the model ordinance, a flag banner sign, they count it as a permanent sign. And if it was permanent, then it's a non-conforming.
Okay, if you consider permanent, but on my understanding is they're considered to be
Yeah,
temporary,
temporary.
and following up with the chair's comments, maybe they shouldn't even be in here at all.
Right, I understand. We have defined them
I
as,
think you're
we have
okay.
defined them as temporary.
I would
I
think
mean,
you're okay.
I don't know whether someone could claim that has had a Dunkin' Donuts banner sticking out of a certain place for 3 years, they could say that's a permanent sign.
it was never allowed in the first place. It doesn't magically become just because it's there.
If something is improperly there, it's not considered a pre-existing non-conforming use. It has to be.
It has to be a lawful starting spot
Right.
before you gain any
Or if it was
vested
there
rights.
before our zoning existed, which was 1970.
Yeah, but flags aren't gonna last.
The flags are not,
Yeah.
all right,
What
okay.
does the township do about one of those?
Don't outthink yourself, Michael, in the sense.
Well, I
that-
just know that my understanding is our ordinance wasn't clear enough that we were allowed to go over and remove them, whereas this says we can.
And we, meaning we go out and.
Not you, I mean, technically the coding enforcement officer has the right to go up and pull them.
Okay.
In the enforcement part of this ordinance, which I don't believe is in the current one.
I don't think there is.
It says that you can't have them, but it doesn't necessarily spell out what you can do if
Right.
you can't have them, besides cite them and.
Okay.
Okay. All right,
I
fine.
consider it
Get 30
implied, but
days to
okay.
say, oh no.
A really valid question. Yeah,
Pay attention.
yeah,
Yeah.
19B. If more than 50% of the sign area is damaged, it shall be repaired to conform to this ordinance. Does that mean 50% of the structure, like a wooden sign, half of the wood is gone, or half of the paper peeled off? Which,
So you're not,
should
actually, if
we
you look,
clarify that?
if you look in here closer, the content of the text does not, you're allowed to change that.
Right, right,
So if the paper written is ripped, that's not a new sign.
okay.
That, and
It
that
would
is,
have to be
that
the
seems
structure,
fairly
50%
common
of the
in the,
structure.
Yeah, that makes
That's
perfect,
okay.
that
Just
makes
has to be
sense.
right,
repaired,
it's the
yeah.
structure,
Okay,
yeah.
Yeah, that makes.
How precisely are we defining the location of signs in the permits?
Sorry, say that again?
How specific are we in defining the location of the sign in the permits?
Well, in the ordinance, it specifies how many feet, height, distance from right of way, all that sort of things. And then in the permitting, it says you must show all the information required to determine if you are meeting the ordinance. So that would say, if you're putting up a 4x4 sign on the side of the road on your property, and I don't remember what it says, the ordinance says it has to be no more than 2 feet from the right of way, you would have to demonstrate that it would only be a maximum of 2 feet from the right of way. No, less than.
If the sign is moved, if they have to re-permit it,
Yeah, I think it's,
Oh, yeah, then you're moving the structure, then it's not, yeah.
does it say that there? It's a good point if it says moved, I think it does.
Usually taking it down.
like if they have a sign in front of their place, and then they move it to the back. And it's pointing right in front of their neighbor's house.
It's a new sign.
It says on 19(2)(a), the sign is removed, relocated, or significantly altered.
Yeah.
Are we giving the signs a geolocation?
If that, in the currents, it doesn't say that in permits and applications under 18(2). Geolocation is not one of the things, but township could add that, like a GIF, like a exact ordinance.
No, because then you're gonna have to do the survey and get markers and stuff
No,
like
you're
that.
doing Google Maps.
Yeah, like Google Maps.
No, we're not gonna, we can't reasonably rely upon Google Maps for our code enforcement.
You can use Google I think you can use Google Maps post hoc if you're like trying to, right, for a legal perspective, you're like, this shows that it's been moved. I mean, the reality is that would be probably a citation and saying you need to get it done, and they would probably say, oh, sorry, here's the new permit, et cetera. And if they didn't, then you would go to legal and then you go and look. But we don't have, I don't think we have the ability to go and document every sign right now in the township.
Well, I mean, an applicant can give you the locations, I say, the geolocation, just by pulling up Google Maps, and they can put that in a comment perhaps. I mean, just so if somebody says, I got a problem with this sign, and they can say, this is the location. And they can point it within a couple feet of where their lane is. Does that make any sense?
I think.
And that can only work for new signs, and I think the reality is most of our new signs aren't gonna be a problem, right? With this, it's existing.
I think we're achieving the goal though of what he's saying with the existing language on the permit and where they have to demonstrate where it is. I think that is one of the options they could give, but it's not going to ultimately be like required to submit.
And by the way, the permit application is not in the ordinance, right? The ordinance specifies that you have to provide the information required. So it's technically up to the staff and the zoning officer to come up with what the permit application should look like, which can also change. So if it ends up, we start running into all these problems, or there becomes technology down the line that makes it super easy for us to map every single one, we never even have to change the ordinance because we're already saying they have to be in compliance with the ordinance. We just have to change the permit application.
They just take a picture of the sign and that's.
I mean, if we felt that was necessary, that could be done by the staff without any legal requirements or passing.
I agree with Michael.
Right, because then it doesn't change the criteria.
It doesn't change the criteria,
It
it
just
just changes
helps.
how you stamp it or not. Okay.
Yeah.
Okay.
Okay, so 19.3 goes over kind of a certification process for non-conforming. So it says to determine the legal status of existing signs in each of the cases listed in 19.2. So if you, the applicant shall submit the following information to Smithfield Township zoning officer, and it goes through a list of things. So
This is
that's
if you wanna update your current sign and determine whether or not it's in compliance.
exactly.
Right.
Number 4, prior to the events listed in 19.2, which would trigger compliance
And non-conformance.
for non-conforming signs. It says non-conforming signs may be repainted or repaired up to 50% of the replacement cost of the sign. The sign copy may be changed and sign faces may be replaced to provide that these actions do not increase the dimensions of the existing sign and do not in any way increase the extent of the sign's non-conformity.
That's I think those two sentences are the more important phrases, to be honest with you.
Yeah. I mean, maybe we could just change briefly the, just 50% of the replacement cost, just kind of have it be tied to the same 50% of the sign area that we referred to earlier.
You wanna?
Well, because I don't think anyone, I think to an extent, some people aren't gonna know what 50% of the cost of the sign is, what numbers, like, I think we're getting a little too into the weeds on that.
Do you wanna strike that sentence and just say 50% of the area?
Yeah, of the
Well, that's
sign
easier
area.
to quantify, to be honest with you. That's easier that will never change. That
Right.
won't change with inflation, that won't change with circumstance,
Yeah,
that won't change with technology. The size is the size
I'm
is the
just saying,
size.
it's exactly like what you have in, the 50% of the sign area that's in 19.2B.
Okay.
Just have that phrasing.
It's a good suggestion.
Yeah, that's.
And then 5, moving on, non-conforming signs shall be exempt from the provisions of 19.2 under the following conditions. I had some questions personally on this, I just wanted to run, but maybe, anyway, A, non-conforming sign possesses documented historic value.
Okay.
It's a little vague. B, the non-conforming sign is of a unique nature or type by virtue of its architectural value or design as determined by the National Park Service, Pennsylvania Historic Museum Commission or local historical commission. So That seems pretty good, because it's as determined by those entities, right? So that's not bad. And then C is good. It says when non-conforming signs required to be moved because of a public right of way improvement. So I don't know, I don't know if we want to better define documented historic value. How do we define documented? That's my question.
I feel like what you're getting with B is a much better way of saying it.
Why don't we just change B to say the non-conforming sign is of a historic and or unique nature as determined by, because you already have the historical commission in there.
That's a good suggestion.
Still doesn't answer.
So strike A and just insert the word.
Strike A and add historic and or unique nature, and then the what reason is one of those groups says so.
I agree. Does everyone else agree? Okay. And then 6, all non-conforming temporary, but we already went over that, sorry.
Yeah.
It was a few minutes ago. Okay, so that ends that section, and now we're on to section 20. Which is signs on the premises of legally non-conforming uses. And so Ron does have a comment on this one. As well, so I guess we can just kind of start by going through this. We're almost done here. Signs on the premise of legally 21, signs on the premise of legally non-conforming uses such as an office in a residential area may remain until the existing use of the premise is discontinued. If a sign wears out or is damaged, et cetera, shall not be increased beyond the characteristics of the sign or signs that existed on the property at the time of this ordinance was adopted. So the third one is the property owner with a legally non-conforming use may, now this is the one Ron had some comment on. The owner of a property with a legally non-conforming use may seek a special exception sign permit that would enable them to install on-site signage on the property that's in compliance with the signage requirements set forth in the district in which the non-conforming use would otherwise normally be found. And then in parentheses, it says, for example, the signage allowed by legal and registered non-conforming restaurant located in R1 would be permitted to install on-site signage as if it were located in ED zone.
EG might not be, we might want to remove, I mean, I like what the legal is, but the example, that's more for understanding.
Yeah.
Well, my comment was where it says seek a special exception sign permit. I said, should that be special? Yeah, not exception, special exemption. Is that supposed to read special exception?
That should be
or am
special
I missing
exception.
Something.
No, that should be a special exception.
Right.
What you want to look at is you want it to go through some way, whether you run it through the zoning hearing board. As
Well,
a
it's not
special,
zoning hearing board, because this isn't in chapter 27.
or as a conditional style use, with some sort of special exception. Or conditional use type analysis.
Well, we just
Where you
did
have-
that, we just created that, right?
Yeah, well, that's coming up. I saw that in the packet today.
Oh, sorry, it will be coming.
But again, the chair is correct in the sense that if we're gonna say special exception use, then it has to be determined by the zoning hearing board where this ordinance isn't there.
Shall be
So you wanna
determined
say-
using similar criteria to you would for a special exception,
I mean, you
and
can
then
say
you don't
that
need
this
it.
is
I guess the big question is, do we feel that makes sense, assuming we get the language correct?
I do not feel it makes sense to make them go for a traditional public hearing through the zoning hearing board. That's
It's not a traditional,
It's not
public- I'm not,
because it's not in zoning.
I'm not suggesting that. What I'm saying is you're using those standards in whatever this.
Well, I
proceeding will be.
agree with that. I just want to
Yeah.
make sure that it doesn't end up
It
being,
can't go to the zoning hearing board because it's not under the zoning code.
just
can't go
making
there.
sure, because I don't want it to become one of those $1,500, like it shouldn't be.
No, you
Prohibited.
can't confer jurisdiction on a board that can't have it. They statutorily can't have it, so. But that doesn't mean the criteria. Go have a good time.
I gotta go, sorry, good luck.
Well, we're
The
gonna
rest of it.
end it like 2 minutes anyway, so.
So we're gonna have to modify that section somewhat, right, based on this discussion?
That's what I would say, yeah, just
And
like we're.
say, go before, you wanna.
Not go before, just say, you could say, using the criteria that you would otherwise if you were examining a special exception request, but you don't want it in front of the zoning hearing board because you can't do it.
So it goes before the supervisors
Like, yeah, that happened for the
for
supervisor.
a sort of a.
For a determination on the request,
Okay,
for a determination on the request, period.
And then you
Okay.
can reference what you'll talk about later.
Yeah, right, that's right. Those are the criteria you're gonna look at. It just doesn't go
Yeah.
through the board. Yeah,
So-
that way, James.
So it
Yeah.
references chapter 27, special use criteria, and then it states in here that it shall go before the governing body for
To the
consideration.
supervisors.
Okay, all right.
I think that is your correct way around it statutorily.
Well, that's the bulk of everything we intended to discuss. There's only two sections left. They're really minor. I don't know if they're, since Michael's not here, if you wanna. You wanna wait till another meeting, or you wanna?
Notifying HOAs of changes in signage ordinance, is that one of them?
We can, it's up to the group. What
Seems
do
like
you
a
wanna
good
discuss?
idea.
Do you wanna talk about HOAs or section 21?
I have a question. I wasn't here for the first session. I was out of town, but I did extensive notes, which are in exhibit A here. I wonder if anyone read them or if there was any discussion or resolution of what I was talking about. Mainly, it was chapter 9, which is off premises signs, where I was saying that both the formula for the size of the sign and the prohibitions on placement of the sign were, I thought, extreme. And I think it's self-defeating in a way to somehow tie the size of the sign to the speed of cars going by, because first of all, it makes all the signs non-uniform. You can make a sign as big or as small as you can determine what the speed limit is. And I think what we need is uniform signs. And I think the best way to do that is just to follow the standard signs of the advertising industry, which are three. One is about 10 by 6, which is 60 square feet. One is what we call a 30-sheet poster, which is the normal billboard, is I think about 300 square feet. And then the third one, which we don't use here unless it's on I-80, would be a super bulletin or supersized sign, which is about 600 square feet. So I would say limiting it to 60 square feet or 300 square feet or approximately, at least gives us uniformity and also makes it very easy for someone to determine what they can put up, rather than figuring out what the speed limit is. Then, even if you get into speed limits, is it the speed limit? Is it the speed of cars? Do you have to go out and put up a speed a vehicle counter to figure out what the average speed is? I mean, it gets very complicated, and it seems like it's very easy to do it the other way. So that was a big note of mine, and I don't know if anyone even discussed it. I wasn't here.
Well, I believe that was one of the areas that we wanted to come back to. And I mean, Alex noted, I think, like 8 or 9 different spots that we wanted to refer back. And I think the plan was to do that after the consensus changes, that we had from now these last 2 or 3 sessions. And we could revisit those before we get to a final draft.
Have we got another session set up?
Well, we're gonna talk about that in a minute.
It's on the agenda.
Alright,
What the group like to discuss. So,
I think in one more session we'll probably be done. Well, I think we'll probably have most of it lined up, right?
Yeah, because
Okay.
I think that makes sense, because I don't think we need to do a final session together. Like, I think we can agree on the changes in the next session, and then we'll have our individual meetings about it from there, and then.
Yeah, that's what I mean. I think one
Yeah.
more. Yeah, okay, we can do that. I don't see right on.
Does that work for like the, you guys keep your meeting schedule the same? That's the 9th.
Yeah, I would presume we're gonna keep this. I mean, we haven't had if the calendar hasn't changed, we haven't reorganized and the rest of it, but I would, presume it's gonna be the second Thursday.
But can we do think we can do it again in an hour?
I think
6
so.
to 7 on January 9th?
That'd be January 9. Okay, you wanna do a 6?
Yeah.
Is that all right, guys?
Yep.
Okay, let's add that in there.
Jacob. Two sections left in here. One of them is a substitution clause, which is there for for the sake that legally we are not, as a community, able to regulate signs by content. So
Right.
basically it says at any time, a non-commercial sign and swap with a commercial message and vice versa as many times as possible. And that's based on the legal precedent. And then section 20, so we were told that that is incredibly important to have in there.
Okay.
So, and this is, maybe Ron could corroborate that, or not, but it's basically, as I understand it, the Gilbert, the Supreme Court case. Essentially language to protect the community.
You can't control content-based language. That's the bug of it. Okay, when you're dealing with signs, you can't say what the sign's supposed to say or not say. That's the no-no. Other than that, you can do whatever. And that's what this clause, I think, appears to do.
Yeah, it's permissive.
And then-
Would that include like advertising a strip club near a school?
Well, it says, that's a good question, and it says, as long as it's not prohibited. Right. And that is one of the.
Right, we've
prohibited
talked
signs.
about that previously, but
Yeah.
I didn't know if this like negates that part.
It doesn't, because it says, provided that the sign is not prohibited
Right,
and the sign continues to comply with all requirements of the chapter, and that. Profane messages are prohibited
got it.
in this, so I think, I mean, the rest of you can comment as well, but I feel that that's covered because of that.
But isn't that in direct, opposition to the court case that you just referenced?
It's
About the
yeah.
message on the sign, if it's legal to advertise a strip club, it's a legal strip club, and then it should be legal to advertise it. Would that cause problems on where it is?
I think it's a legal question, I'm not a
I
lawyer.
think if you're regulating content, that's a problem.
Well, they're only zoned for the industrial zone. I mean, that's not going to happen next to a school.
If there's already a non-conforming?
There
next
is
to
not,
school, and
It's
then,
not, but it's not here, Chris.
there is not.
There isn't one here like that. That's not, you couldn't even jam one in. Take a
Right.
jam one in.
okay,
I mean, I already know where Delilah's is.
The last section is violations, and so there's some language in here. Which I would recommend legal review on. But there was one item I wanted the group to be aware of. As currently written, there's no minimum fine and the maximum is just 500. In other ordinances in your community, the maximum is, it doesn't say you're gonna get, it's 1,000 maximum. And I talked to your zoning officer, he recommended a minimum. And there was some discussion of a 300 minimum. And a maximum, you guys can decide that, but that's kind of what I wanted to bring up to your attention, and then we're done with the supervisors.
Yeah, I don't know that I have an opinion based on his. I think that, we can, why don't we tie it to the fee schedule? That way, as long as that's permitted like it is for the nuisance alarms and things like that. We do that, I think that'd be better, because especially if. For some reason, the legislature lets us have higher fines or changes the nature that we don't have to amend every. Ordinance we're trying to adopt now to tie it to that. So we can tie it to the fee schedule, that would be great.
Can I ask Julia on this one? I hate to put you on the spot, but I'd be honest, I'm not 100% clear on this. With
I would
regards
say,
to enforcement fines.
I would say, Doc, as following up as to what the chair had said earlier. About, say, a sign on the side of a building. Let's assume some barber shop puts a sign on the side of the building and it was wrong in some fashion or whatever. Do we really need a minimum fine for something like that? Don't we want the magisterial district judge to use his or her own discretion to say how much that would be? So, I mean, if the township wants a minimum, that's a policy call, it's not a legal call. I'm just saying that if you set a minimum, let's say $300, which is sometimes a frequent number used. That might be a little steep.
People
on
forget
a
because
violation, you
it's, cause if you do get the violation, I mean, presuming it's something minor like that, which shouldn't really be brought, but two. It's not like court fines are like $10, you know, you have to pay $170 for, you know, all these. Access to justice and all these different, you know, funds, if you do have a violation. I don't wanna go with a minimum, I'd rather let them exercise the discretion. And if we can tie the maximum, take, you know, to the, I guess that's not necessary, yeah.
You wanna strike? It says, shall constitute a separate offense punishable by a fine not to exceed.
That's fine,
You want to-
leave that for. Yeah.
Put in the minimum.
Okay, you wanna reference the fee schedule in there?
No, not with that change.
Okay, do you want legal to review this section or just leave as is?
Well, it's all gonna get reviewed in a little bit, so. Make, you know, these changes that we agreed on, and then let's. Flesh out in the, you know, the next hour session that we have the. Last few points from the other 8 or 9 sections, and then we're good.
Okay, so I can put this in a ordinance, a draft ordinance form, and then I will highlight the dozens of. Comments and progress you made and come back in January with that document.
Yeah, and if you can distinguish, just to make it easier. You know, where there was consensus versus where we really actually should discuss. And then if that's to us, you know, at least a couple days ahead of time, then we can. Hopefully maximize that power hour. Cool.
Yeah, Bart.
Yeah. You have a quick moment, I will.
Okay,
Thank
then I
you.
gotta start my planning commission meeting, so.
Okay, no problem. Commend the body for talking about sign ordinances. There are a couple of comments you might want to consider from somebody. One, Ms. Lohan's perspective on picking out the size of your sign is. That's the first thing I noticed when I read through the ordinance myself. Make it simple, make it easier for your customer, the person who's advertising, that he knows what 1, 2, 3 size signs you can do. Use an industry standard. That would be my first suggestion. I also feel that perhaps you might want to review how close a sign can be from, it's section F. No closer than 1,000 feet from a park, church, cemetery, school, or residential district. Residential district makes it tricky, because if you look at your zone in which you're permitted to put a board. All of those zones are within, I think, close to 1,000 of residential, so you're terminating all your signs. So you might want to just review that. And if the idea is to terminate,
Not
then you
seeing the
get.
downside.
Yeah, what's your point?
Yeah, so if if it is to terminate your signs, I get, then you skip the whole ordinance and make that easier. Make
Need a
one
gavel.
section on the ordinance, so if that's the idea, I got it, then I understand. Then if that is the idea, my third comment I won't give you. But I would also, if you're gonna do signs, making them 1,500 feet apart is probably not practical as well. Means you're gonna have businesses that are closer than that, but then you're gonna, again, not have any.
The state regulation on state highways under Title 67
Is
is 500
500 feet.
Let me just ask quickly, is that like a general requirement, or is that just on the same parcel? Because obviously everyone has like their vested right to their sign for their own business.
We're talking about off.
Just-
Is that all?
Yeah, okay, that's what, all right, that's what I wanted to make
Billboard.
sure,
Just billboard.
okay.
Yeah, so you just may want to, before your next meeting, kind of talk internally, just so you know, but again, my comment is to commend the body for doing this. Because I've been to others and it's not done and it's not clear. And then we have to go to Scott and try to figure it out.
Yeah.
Thank you.
All right, you ready? Did move to adjourn here so we can be on? We good, Jake?
Oh, yeah.
Okay, I move to adjourn this particular meeting.
Second.
Okay, all in favor?
Uh,
All right, everybody, let's take 2 minutes here.
Thank you,
And
guys.
then we'll do the planning commission.